Garden State GSCLE. 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 Garden State GSCLE.
We are back with Robert H. And the H stands for Hearts, does it not?
Henry, but Hearts is acceptable.
And I'm talking about like Hearts in poker, not Hearts, the other kind, like the mountains. That's right. Yostemsky, career prosecutor, sometime defense attorney, although not much recently, and 12 years, was it, as a municipal court judge?
Yeah, I'm not sure I'm a career prosecutor, but if that's the label, then I'll have to work.
Well, that's all you do for a living.
Now.
Yeah, now. And you've been doing it that way for years, right?
Yeah, but it's perhaps the most recent part of my career, not my entire career.
Well, you're.
I didn't know, quite candidly, that I had a career, but I'll accept that.
Well, except for the last 15 years, you've been a career prosecutor. How's that sound?
I will, because I have. Yes.
Okay, good.
Yes.
There's some verisimilitude in what we're talking about. I got to tell you a funny story. A guy called me up a week or two ago who was going through our website and said, will you help me out? I can't find the CLE on conditional discharges. And I said, well, there's a good reason for that. I never did a conditional discharge CLE. And he said, why not? And I said, well, because everybody knows everything there is to be about conditional discharges. And he said, well, I don't know anything about it, and I want to learn. So I thought, well, maybe this would be a good opportunity to do a CLE on something which, that's the mistake. You see, you and I, since we deal with this stuff all the time, we just assume that everybody knows about this, right? Yeah,
and I guess no one else has done the conditional discharge?
No.
Instruction?
No, it's just so weird. I mean, it's just, sometimes there's these issues you just assume that everybody knows about, and, so it's high time we did something on conditional discharges.
Do you remember the old conditional discharge?
24, 21, 27,
well,
section
good cite,
27.
Good cite. I could not cite it, but I remember the old days. Under the Food and Drug Act.
Yep, and so it was in Title 24, and it went out of business very shortly after you became a municipal court judge, as a matter of fact, when the Comprehensive Drug Reform Act went into effect. And, things were kind of different in those days. This was kind of at the beginning of the crack epidemic that plagued our country in the mid to late 1980s. I remember you as a municipal court judge in those days having to deal with all these drug cases, especially down in the Trenton Municipal Court when you were sitting as a visiting judge, and just having so many drug cases coming before you. Do you remember those days?
Yeah. The new thing then, I think, was the $500 DDRA, or drug tax, as we call it.
Right.
And that was simply a very large amount of money, disproportionate to the offense, many thought, and many think to this day.
Well, the one thing, they have not changed it. It's still $500, even back from 1987. This is the Comprehensive Drug Reform Act. It's the Drug Enforcement and Demand Reduction Penalty. I think that's what the official name of it is.
Yes.
DDRA. And I remember you having to impose those things, and in those days there was no way to get rid of them. The only way you could get rid of it was just to pay it, right?
Yeah. Although recent legislation has allowed that, together with VCCB and the other component penalties, to be worked off through time served at the local correction center.
Right, which is, I think that's a fair and practical way of getting around these things.
It had to be, because the same individuals would never pay, and they would be arrested and released, and this would go on in perpetuity. So
the starting point for our analysis is really twofold. Number one, we have the conditional discharge. They used to call it Section 27, so the old, now repealed, 24:21-27, which was in the Food and Drug section, repealed and replaced by the Comprehensive Drug Reform Act of 1987. And before we get into the specifics of it, I want to just talk about something that's really more philosophical than anything else. And this goes back to, really, this pre-existed the Comprehensive Drug Reform Act, but it's a policy determination that's been made by our legislature. And that is that people in New Jersey who are kind of run into the criminal justice system are only to be afforded one diversion, so to speak, from the criminal justice system in their lifetimes. So at this point in New Jersey, we have 3 diversions that I'm aware of. One is pretrial intervention, which is countenanced not only by statute but also by court rule. The conditional discharge, which we just talked about, and then the recent, at least I think went into effect in January of 2014, the conditional dismissal program in municipal courts. So you get your choice of one, and then when you get the one, that's it. You don't get any more. You don't get any further diversions from the criminal justice system in your lifetime. Now, I'd like you to talk about this from the perspective of a prosecutor, because if you said some young fellow coming in to see you, a young woman has a drug offense, and they have the option of getting a diversion from the criminal justice system through a conditional discharge program, would you ever try to dissuade them from doing that, in the sense that it may be a bad idea for a young person to use up his one strike so early in life?
Yeah, I think we've discussed that before. From my perspective, if such an individual comes in unrepresented,
Right.
it's a lot easier if they are represented, because they and their attorney can make that decision for them. However, if they're unrepresented, it seems to me a free bite at the apple, if you want to call it that, is to be taken when the apple is bitten, so that you don't want to hold that in reserve for a future violation, which you believe very likely or certainly is going to take place, because that's somewhat speculative, even though it may be likely with that individual's...
Likely or certain?
Well, let's use likely, considering their lifestyle and the circumstances and projected future activity. If you need a get-out-of-jail-free card, and you have a get-out-of-jail-free card in hand, why not use it? And that's my general position for individuals who are seeking diversion. I would say one thing about the new municipal court program, PTI. It's been in effect for 5 months now or so, and I've yet to see it used.
Really?
Yes.
Why do you think that is? Just because it doesn't meet people's needs, or not enough people know about it, or do you have any reason?
I think it's somewhat complicated, and the same thing can be accomplished through more creative means in the court structure.
You know, the funny thing is, though, I had a young lady come in the other day, and this is precisely the situation we're talking about. She's 18 years old. She has lousy friends. She has a shoplifting case, which went to the prosecutor's office and was downgraded. It's a perfect case for diversion, in the sense that she could get into the conditional dismissal program in municipal court. But I just had such misgivings about it, because I'm positive she's going to get herself jammed up again at some time in the future, you know, because she's going to be in a car that's stopped by the police, where the cops find drugs, or somebody has a pistol, or, you know, some crazy thing's going to happen to her where she's going to really need PTI and not be able to get in.
You may be aiding and abetting a criminal enterprise with that kind of thinking, but that's a different theory. I understand exactly what you're saying, and for her, in that circumstance, it may be absolutely correct not to take advantage of one of the diversionary programs, but that's a very exceptional situation, and she's an unusual and actually very sad case study.
Do you, as a prosecutor, do you see your role different as a prosecutor than as a defense attorney, in the sense that, would you try to dissuade someone from a conditional discharge who was young like that? In other words, would you give the same advice to someone who's there that you're prosecuting, as opposed to somebody you'd be theoretically defending?
I think it's pretty much the same. I think the players in the arena, that is the judge, defense counsel, public defender, prosecutor, and experienced police officers, all know the lay of the land, so that they're thinking of what the realm of possibilities are and which of those possibilities are most appropriate in this particular individual's case for promoting justice. I think that mindset, the thinking, is right along the same channels if you have experienced people, especially people that have worked together. So for an individual who is unrepresented and I'm dealing with in that scenario, I don't think my advice to them would be different than your own. And I did work with you for quite a number of years in various capacities.
Which, by the way, is nothing to be proud of.
Well, I'm confessing, it's a full disclosure. When you worked as public defender, also when you were on the other side, when you were working as prosecutor and I was defending public defender and also private.
Now you're talking about something more than 30 years ago, so
Let's
not open up civil wounds.
This gray hair is not there for nothing.
So let's talk about the conditional discharge as a process, which is involved enough. But then I'd like to really kind of get into some alternatives to the conditional discharge, because I think it's something that you've got to think really long and hard about before you have a client, especially a young client, take advantage of it, because it can come back and really very, very adversely affect them later in life. So let's just kind of talk about it first of all. The statute is 2C:36A, capital A, -1. It's really kind of an expansion of the Section 27 that we talked about a few moments ago. It's really the legislature's response, circa 1987, to continue on with this diversion from the criminal justice system. And typically it's reserved for people, first of all, the first step in it is that these are individuals who have never had a diversion from the criminal justice system previously. So if you've had a previous conditional discharge, if you've had a previous PTI, so to speak, or if you've had another conditional discharge, either under the current 2C:36A-1 or under the former Section 27, pre-1987, you're statutorily disqualified. But one thing for sure, I mean, the first question you have to ask your client is to make sure that your client has not had a previous diversion through PTI, certainly through conditional discharge, certainly, or Section 27, or through the new conditional dismissal program, municipal court. Each of these statutorily will disqualify you.
Yeah, but the client may not know or be candid, quite surprisingly.
Right.
So that ultimately the only way to determine that is to run a criminal case history. And you really can't do that as a defense counsel unless you use the court's processes, or you can, but it's an expensive, time-consuming process, as I understand it, to have someone go to the state police and pay a $25 or $35 fee and have their fingerprints taken and run the criminal history and have that provided to them.
That's just not going to happen.
It's a rarity, but perhaps some defense counsel do that.
Now let me throw a curveball at you. Supposing that your client did have a conditional discharge previously, all right, and completed it successfully, waited 6 months, and then made an application for an expungement, which was granted. So once the expungement is granted, two things happen. Number one, all the records related to it are taken away and isolated. And number two, the defendant is allowed to legally claim that it never happened. So, but does a defendant have any type of obligation to reveal that he's been subject to an expungement?
Well, I think the expungement statute itself...
In this context?
Yeah, but there are exceptions to the expungement. That is to lawfully lie, that is represented as though it had not taken place. And one of the exceptions is the court process. Applying for a position with the court or probation or sentencing. And I'm not sure. I believe that the criminal histories that we obtain still do identify, at least by way of summary, conditional discharge as opposed to a 0. You'd see a 1, even though the expungement had taken place.
Yeah, I've never seen it that way. Now, what I have seen down in Trent Municipal Court is conditional discharge is 5. That I've seen. Okay, where people will get 5 conditional discharges.
We assume that's most likely an error.
No, it's not an error at all.
Or good lawyering, but that's why we get the criminal case history, so that we're able to identify ineligibility. And clearly, if a number is 5 there, something wrong took place in the past. We don't want to compound that by having another wrong take place presently or in the future.
Have you seen them where you get...
I've seen multiples, and we look at it and scratch our head and say, we're not going there in this particular case.
Well, it's just an interesting legal issue because I know that you have to reveal the fact that you had an expungement for employment with the judiciary, with law enforcement, and with corrections. I don't know that you really necessarily have to reveal that you had an expungement when you're applying for a conditional discharge, but by the same token, the judge, I think, is statutorily granted access to that to make that determination. So it's just kind of an open issue.
Well, it's an interesting issue in that it's like disclosing prior DWIs in sentencing. Many defense lawyers take the position that, Judge, it's wrong to place my client under oath and ask him or her if they've had priors, because it's not our burden to reveal or disclose or volunteer. Rather, it's the state's burden as part of the sentencing process to identify priors so that my client would be treated as a second or third time offender. And there's some interesting argument there. I've seen judges go both ways on that. Some say, yes, you're absolutely right. Others say, I hear your argument, I'm disregarding it, I compel your client to answer if he or she wants the benefit.
Got it. Now, after you've gone through the process of determining whether or not your client's ever had a previous diversion from the criminal justice system, the next step is to see whether or not your client has ever been convicted of a drug offense anytime, anywhere in the United States. What I say to my clients typically is, now when I say convicted, I mean stood up in court and pled guilty or been found guilty after a trial, either in New Jersey or any other state. And I probably should add the federal government too, I never do for some reason. But that's the second requirement, is that they can't have any, any prior drug convictions. Agree?
Agree, but that's much more difficult to investigate from the state's perspective. It's difficult to get a national criminal history, and I assume the national shows federal convictions, but we see them so rarely, although I do see them on occasion. In fact, I saw one either last week or earlier this week, which had that information, but that's a very unusual type of preparation.
Now, do you take the position as prosecutor that when they talk about prior drug offenses, at least for New Jersey purposes, they're really referring to offenses that are defined under the Comprehensive Drug Reform Act? So we'd be talking about offenses that are defined under Chapters 35 and 36 of the Title IIC of the New Jersey Code of Criminal Justice.
Yes, and I believe there's still some Title 24 offenses that may carry over that might be eligible for conditional discharge.
But other
I think
offenses,
I've had that.
for example, let's say the guy had a conviction for loitering for the purpose of just obtaining or distributing drugs. That's 2C33.2 something.
Dash 2.1, yeah,
2.1.
that would not be eligible. It's not part of the...
When you say not eligible, do you mean that that would disqualify the person, or he would not be disqualified if he had a prior offense?
Well, it would not disqualify the person, and if the person came in with that fresh charge, they would not be eligible for conditional discharge treatment, because that doesn't fall in the category of those that are dischargeable through that diversionary program.
Right, but if the guy came in, he had that on his record, and he's got a new drug charge.
Doesn't count.
Then it would not count. He would not be disqualified then?
Yes.
Because it's not codified under either Chapter 35 or Chapter 36?
Yes.
Okay.
Or Title 24.
Or Title 24.
Depending upon how far you go back. And what
See how
the offense
complicated
was.
this stuff gets? And you and I just assume this stuff because we just do it every minute of the day and night.
Well, you see it, and after seeing it enough times, you're comfortable with it, working with it.
In my case, it's been more than enough times. Now, so first thing, no prior diversions. Next, no arrests resulting in conviction for drug offenses. New Jersey, any other place, federal. Okay? Number 3, not a danger to society. In other words, you're not going to be some kind of a menace. What do you think?
Try making that argument, although who can identify someone else as a danger to society? But if their record were such that you actually felt that, you might make the argument. I don't think I ever have.
No?
That's somewhat too unusual.
Let me just take a second here. I want to actually read the language in the statute because it's really kind of funny.
Yeah, I looked it up a moment ago while you were talking about its effective date, July 9th of 1987, so it's been in use a long time now.
So we want 2C36A1.
A-1, yes.
I want to see the part where they talk about you can't be a menace to society, because I have a lot of menaces to society. Let's see. Here it is. The defendant's continued presence in the community or civil treatment program will not pose a danger to the community. Okay? What do you think? You ever had that come up? Where there's been an argument that the guy's too dangerous to be out in the community?
I don't believe so. I've had the situation where police officers that have filed the complaint don't want this particular individual diverted for whatever reasons, either prior contacts or the nature of the investigation that resulted in these charges, or perhaps a search warrant that should have yielded tremendous contraband, but for whatever reason only came up with disorderly persons contraband.
Right.
I mean, there are a number of reasons, but from my perspective, it's something that statutorily someone should be entitled to almost as a matter of right.
Got it. Now, assuming the person is not a danger to the community, the next one is really much more amorphous, but it really kind of, you have to demonstrate that your client's going to benefit from a conditional discharge, and I don't see how you would not. Here's the reading of it. It's under section C2, that the terms and conditions of supervisory treatment will be adequate to protect the public and will benefit the defendant by serving to correct any dependence on or use of controlled dangerous substance that he may manifest. Okay? Now, there's two things going on here. Number one, I mean, every defendant who's diverted is going to benefit from it in some way, but they're not talking about it in that context. They're talking about benefit from some type of dependency on drugs, right?
I used to ask the court that the state is advocating this diversion and mention those criteria in the application, but it became so superfluous that those comments are not made either by defense counsel or the state at this point. It used to be somewhat more significant when loss of license was involved potentially, and still can be for conditional discharge, and we asked for that diversion with no loss of license. But how many years ago you would know the statute changed in that even after a conviction for a drug offense these days, if you have special or compelling circumstances, you don't have to lose your driver's license.
Actually, what happened, there were two different amendments. The first one dealt with convictions. Then the legislature came back the following year and re-amended the conditional discharge statute to have it parallel that. So,
which was a good thing, because the loss of license is a very terrible result for someone possessing marijuana on a street corner, for instance, waiting for a bus that has nothing to do with their driving, yet that was a collateral effect.
So I just want to read this again, Bob, because I have a thought about it. The terms and conditions of supervisory treatment will be adequate to protect the public and will benefit the defendant by serving to correct any dependence on or use of controlled substance that he may manifest. Now, the problem is, in my experience, the vast majority of judges don't impose any conditions on defendants at all. In fact, it was the exception when a judge would impose conditions on somebody, and sometimes the defense attorneys would get angry.
Yeah, I've heard many times, will we have to come back for this? Because some courts still do, at the end of the term, be it 6 months or a year or 2 years, require the defendant return to court and run the criminal case history to be sure that, in fact, there has not been a violation. But some courts still do require a urine test or or 2 or 3, which has to come back negative in order to continue progress in the program and successful completion of the program. But that's very clear, a minority of jurisdictions at this point.
It seems to me that it ranges a lot by county, in the sense that there's certain counties where the county probation department is actively involved, so the judge will just put them on probation, and they'll get contacted once or twice by the probation department for the purpose of having a drug test. But then there's other jurisdictions that just nothing happens. They just say you're on a conditional discharge and behave yourself for 6 months and the case will be dismissed.
I think that's the more traditional view, at least in this part of the state. And I think it has to deal with the number of these cases that come through. It's just a terrible burden which requires a tremendous amount of government resources to try to monitor individually these defendants for conditional discharge, when those resources could be much better used to monitor more at-risk individuals.
Now, on Section C3, we talked about that before, that cannot have had a previous diversion from the criminal justice system, and C3 has been recently amended to add in the conditional dismissal program out of municipal court, as well as one of the disqualifying diversions. So you really, again, you have 3 statutory diversions, 4 if you count the 24, 21, 27 repealed statute.
Well, this might be a good point to mention that one useful defense technique is, if you have an individual who has recent drug offenses in time, and even in different jurisdictions, there is case law that allows for a consolidation of those to discharge them at the same time, to take advantage of the rehabilitative aspect of that section of the code. Sometimes it requires, if there are different counties, that you have to file applications before the assignment judges, and then you have to determine through the assignment judges if they're going to consolidate, which county they go to and which court wants to accept them. But it's a very useful rehabilitative procedure for an individual, which I think is what the statute's really designed for, who's new to this criminal justice system, has potentially some drug problem, is going to have it corrected, is doing their best to give them a fresh start.
You're referring to the appellate division decision, Estate versus Gray, and my experience with that is really there's three different scenarios. The best possible case that you get is where the defendant has two unrelated open drug offenses, but both in the same court.
In the same court, and not too far away in time.
Yeah, fairly. They don't necessarily have to be a crime spree, but fairly closely related temporally.
Because that's what the judges look at. They have, when was this one, when was this other one? And if they're close in time, then there is a tendency to allow them to treat both under one conditional discharge, and I think it's very good lawyering as well.
So if you have both in the same jurisdiction, that's the easy case. It gets more difficult when you have two open charges within the same vicinage, in the same county, but in two different municipalities. There, you're probably going to have to go to your local assignment judge to get a consolidation order, moving them from one court to another, and then making your application for two conditional discharges under State versus Gray in front of whatever court the assignment judge selects. And then the third possibility, which you alluded to, which is the worst of all cases, is where you have to get not one but two assignment judges to go along and get the case transferred from one jurisdiction to another. That is a gigantic mess. And sometimes get resistance from one of the assignment judges who say, forget about it, I'm not doing it.
Yeah, but it's a proper advocacy for your client as defense counsel. We see that also, that technique in DWI cases. There you get less resistance because the DWI travel scheme is a continuous single event, so that the assignment judges agree, well, this should be in one place.
Right, it's a continuing offense.
Yeah, then they just have to figure out which place. But two isolated independent drug offenses is different, but the advocacy there is entitlement under the conditional discharge statute, and case law says it's the public policy as to why it should be done. So I think a strong advocate could convince the assignment judges that that's the appropriate disposition for their client, and more importantly, the interest of justice.
So no danger to the community, no prior convictions, no prior diversions from the criminal justice system. You'll be aided by the conditional discharge in terms of breaking your drug dependency, which is more honored in the breach than anything else. There is a mechanism for consolidating more than one open offense before one court to getting multiple conditional discharges in one transaction.
Well, let's say two. I'm not sure if you went three or four, whether that has the approval of reported case law. It may, but I'm just not.
I'm not familiar with it. The most the appellate division was willing to go in State versus Gray was two open matters.
But why limit yourself to that? If you have that situation, it's certainly worth a try if all the cards line up that way.
Now, once you've gotten by these preliminary hurdles and the judges made a determination to admit you to the program, and there's no objection of the prosecutor, and I can't imagine why there would be, the next thing you've got to be talking about is money. Now, you alluded to the drug enforcement and demand reduction penalty. I think it's mandatory in every single case. The only thing I think that will kind of reduce it is if you've gone into some type of program on your own and paid for your own rehabilitation. To the extent you've paid for your own inpatient rehabilitation, you can get a credit, dollar for dollar credit against your drug enforcement and demand reduction penalty. But that's going to be an extremely rare case. But
a good case, it's an offset, so that's an appropriate use of those funds to get that kind of help. And I think the bottom line, dollar-wise, is $833.
Well, let's go through it, because you see, the money is spread all over the place. It's not just in Chapter 36. You've got to look at some other statutes. So I want to kind of go through it step by step, see how good your memory is.
Well, my memory is, subject to your actual calculation, 833 if there is a lab fee required, and 783 if there's no lab, such as for paraphernalia.
Now, I'm going to probably teach you something that you never even thought of.
It won't be the first time. Okay.
Here's a little trick. If you have a guy who's pleading out on a Chapter 35 charge, possession of marijuana, for example, okay, there's a $50 laboratory fee, okay? Same guy pleads guilty on Chapter 36 charge, possession of drug paraphernalia. There is no lab fee because there's nothing to do. There is a lab fee for the conditional discharge, regardless of whether you plead out to Chapter 36, or whether it involves Chapter 36 or Chapter 35.
I did not know that.
You see?
And most judges will not impose that, but thank you for the education.
All right, that'll be $500, please, for legal advice.
Well, I'm going to use it for rehab.
So you get a $50 lab fee and a $500 deeder penalty. We're going to keep track of this on the screen to see what it comes out to. You have a $75 juror fee, and I guess they call it that because the money is supposed to go to pay jurors, right?
I think it still is used for that fund.
At $5 a day. Get some quality justice for that.
That's a lot of jury time.
By the way, how can they have a minimum wage in New Jersey of, what is it, $50 an hour or something like that? And yet, for jurors, they only get $5 a day. What's that all about?
Public service.
But is that an exemption to the minimum wage law? Okay, so we've said deeder, 500, lab fee, 50, juror, 75. Dare penalty, I think, is $50, right?
Okay.
I'm not sure what DARE stands for, but it has something to do with fighting drugs, okay? Then you've got your traditional $75 Safe Neighborhoods Fund, right?
50 VCCB.
50 for the Victims of Crime Compensation something. They're either a board, an organization, or an agency. I'm not sure which. They keep changing their name, I guess, to avoid the police. I'm going to say A, VCCA. You and I as old-timers, we say VCCB just from force of habit, right?
We do.
We have your basic court costs of $33. All right, so let's add all this up, Bobby. Okay, so 833 American dollars. Now, the good news is no sales tax on this. None, not one single penny.
Well, I don't think you'd convince the individual paying those monies that no sales tax on that is good news.
Yeah,
they would consider it all a tax.
Well, you know, the funny thing about this is, legally in the old days, we used to have to make these very fine distinctions between penalties, fees, assessments, fines, and all this other stuff, because they actually have hyper-legal distinctions associated with them. The law has really kind of relaxed now, and we don't have to make these types of distinctions anymore. But the bottom line is a fine, much like jail, is imposed to punish people, okay? Penalties, these other types of things are either revenue-raising or they have some other purpose. For example,
User fees.
user fees is another one. The drug enforcement and demand reduction penalty, all right? There are two cases that discuss this. Very easy to remember. State versus Bulu, B-U-L-U, and the other one, which is, you can't possibly forget, it's a cocaine case, State versus Blow, all right? Now, I believe it's State versus Blow where the appellate division says, you know, the drug enforcement demand reduction penalty is really not to punish anybody. It's rehabilitative. It's to rehabilitate the defendant. And I used to say to my public defender clients, look, you have to pay this $500 drug penalty, but it's to rehabilitate you. You're going to feel so great about it. You're going to feel like a new man. And they would look at me like I was insane, you know? The whole point of this is $833 is a lot of money. And this is not one single penny of this is fines. It's just money. But to people who have to pay it, it's transparent to them. They don't care whether you call it a fine or a penalty or a user fee or anything else. It's just money out of their pockets.
It makes no difference at all. And when I would tell an individual unrepresented that it's $833 and these are not fines, they're penalties, it does make, it's still money they have to pay, so they would call it a fine.
Right.
Even though it's not technically that.
And I would always feel guilty in court. As a lawyer, you want to be very precise with your language, and I would never call this a fine because as an attorney, you really have to be much more precise. But to clients, I would use the word fine, just kind of unofficially, so to speak. I have to tell you kind of a funny story. Many people would not be aware of this, but you know, for the definition of consequences of magnitude, you have, by case law, establishes that if it's any time in jail, even 1 day, as a consequence of magnitude, then you have license suspension of any amount, that's a consequence of magnitude. The third one deals with money, and in the guidelines of the rules of court, they set the amount of financial consequences for consequence of magnitude at $750. They got that from the conditional discharge, because that in those days was about the amount of money that you were going to have to pay to get a conditional discharge of $750. So that's why they've equated it. And the Supreme Court has actually kept that number for quite a number of years now. But it relates back to the conditional discharge.
And I remembered it consistent with the second offense for driving while suspended, because that's a $750 fine. So
got it.
that's the way it's stuck in my memory. unbeknownst to me, there's some conditional discharge relevancy.
You see, you come here, you'll learn all kinds of stuff.
Well, but the $500 for the deed drawer goes into a state fund, and then that fund is dispersed through the counties and the municipalities, municipal alliance committees, which make determinations how to spend those monies that are returned to the communities to promote drug awareness and drug prevention programs that are particularly relevant and appropriate to their particular locale.
Now, it's interesting because I think there would probably be a big difference between the DETR penalties, the drug enforcement and demand reduction penalties imposed for conditional discharges, as opposed to those that are imposed upon a conviction, okay, either in municipal court or superior court. Because the person who gets a conditional discharge really has much greater skin in the game, so to speak, much greater motivation to pay, because you're not going to get your conditional discharge unless and until you pay off all the drug penalties, right?
That's true. So it's somewhat economically biased, but it is a condition.
Right.
Is complete the terms of the program, which include payment of the mandatory fees.
Now, one of the things I would tell my clients was this, and this is really kind of good advice to attorneys out there who are confronted with this. You may have a client who will come to you and want to get a conditional discharge and then say, look, I want to do X, go to school, join the Marine Corps, whatever it is. And I'll say to them, look, the judge is going to place you on a period of unsupervised probation, probably for a year, and you're going to have these drug penalties to pay. We can always go back and ask the judge to give you less time. But the judge can't do anything to help you if you still owe money. So it's in your best interest to pay off the drug penalties immediately or as quickly as possible. Because if that's really the only thing that's holding you up, if you could just make a palpable case that you're rehabilitated and it wouldn't serve any useful purpose to continue your conditional discharge, we can ask for an early termination of it. But you're never going to get a termination if you still owe money. So, I mean, you've really got to stress to them how important it is to pay the money.
Yeah, and I've seen judges very receptive to individuals who are scheduled to join the military and have to resolve this drug charge prior to that happening, and have them cut the conditional discharge period short, 2 weeks, for instance, in order to have this totally behind the individual before their entry into the military service. Another complication is the immigration factor. It's my understanding, although I'm not certain of that because I'm not an expert in immigration law, that for purposes of deportation, a conditional discharge does not suffer the same consequences as a conviction would. But again, I know it's an issue. I don't know the answer to the issue, but from what I've been led to believe, it's not a deportable event.
I don't know the answer to that. Any attorneys who are watching this, so this one piece of advice I'm going to give you that they can pass along to their clients is this, especially in a drug possession case, or most importantly in a marijuana possession case. You've got to save a copy of the State Police Forensic Laboratory report that'll show the weight. Because if the weight is less than 30 grams of marijuana, which it almost always is, even though theoretically the DP can go up to as many as 50 grams of marijuana, for 30 grams of marijuana or less, it's not a removable offense. Okay,
So that's the cutoff.
That's the cutoff. But you've got to have proof of it, and the best, most satisfying proof is going to be the report from the State Police Forensic Laboratory. So what I tell clients is this: look, you can get an expungement and get all the stuff wiped off the books, but before you do anything, get that State Police report and put it in a safe deposit box. So in the event later on in life you need it because you're going to be applying for citizenship or there's some effort to expel you from the country, you'll have this available to you. You won't have to go through the process of filing a complaint in Superior Court to open up the expungement. You see what I'm saying?
Yes, very
They should
important.
have a copy of that available to be utilized. Or they're going to take the bar exam, for example, and they've already expunged it. I got to tell you something, the Committee on Character is going to want to know everything. And you should be able to show them the reports, disposition on the case, how much drugs, that type of thing.
And there you're required to disclose. It's not a question of them discovering it. You have the affirmative obligation to reveal.
Precisely correct. So, I mean, these are all kind of things to think about. On these drug penalties, though, they're out there. They have to be paid in order for you to get a discharge. So it's in everybody's best interest to advise your client to pay it as quickly as possible, or if you're placed on some type of a payment program, to stay current with your payments. Because the last thing you want to do is be thrown out of a conditional discharge program based on not paying money. It's kind of silly.
And I'm thinking, I've seen so many of those in the city of Trenton, where I prosecute as well, that perhaps that's the greatest reason for failure of the conditional discharge program, not following through with payment of the fees and penalties.
Right. It's just kind of silly, but you've got to stress to your client the importance of doing it. Now, getting back to time for a second, again, for some reason the judges will normally select a year as the starting point for these things. We've already talked about a couple reasons why you want less time. For example, you have a date with some kind of Army or Marine Corps recruiter or something like that. And you've got
who occasionally accompany the individual to court for the
Sure.
proceeding.
They just,
and then when that happens, everyone realizes this is for real. This person's not misrepresenting something.
But the key is you got to understand that you need to have all of your ties with the civilian world cut. You can't have any obligations to courts or anything like that. It's all got to be done before you can go into the military. Something else that comes up, though, there may be occasions where you want to get an expungement. You need it kind of expunged from your record. Well, you can get a conditional discharge. The problem that you run into is after the conditional discharge is granted, there's a waiting period of 6 months. So you've got to wait 6 months before you can apply for your conditional discharge. So it may be if you need an expungement quickly, go in, get your conditional discharge, pay the drug penalties right away, petition the court as soon as possible thereafter to terminate the conditional discharge so that the 6-month period will start running sooner rather than later.
I just had a thought. It's somewhat taking a couple steps back, but what would be your position, as I'm seeing with increasing frequency these days, of a criminal history that shows a drug offense and disposition guilty, but the disposition was downgraded to a local ordinance? Would you argue that that's a disqualification for conditional discharge eligibility or not?
No, I don't think it is at all.
Which is my position as well, but we're seeing that with increased frequency. I have heard the argument that it was initially a drug offense, therefore that should be a disqualification. But I think I read the statute more literally, or the social policy more constructively, as that would not be a bar.
See, look at the legal issues that are involved in something like this. Okay, you've got about 3 or 4 distinct things going on here. Let's just kind of think it through. You have somebody who walked into municipal court with or without an attorney and engaged in a procedure which is outlawed in New Jersey. You can't take a drug offense and kind of create it by waving a magic wand into an ordinance violation. The legislature has spoken on what these drug offenses are, and local municipalities are preempted from enacting and enforcing ordinances where the state has already spoken, so to speak. So going through this process of letting somebody plead to an ordinance violation, probably prohibited certainly by statute. I would suspect there's easily 3 to half a dozen appellate divisions cases that say you can't do it, although there's no specific court rule or guideline in the plea bargaining rules for doing it. I think in the sense of the guidelines, you shouldn't be engaging in this type of stuff. But then throw into the mix, the guy might have already completed his sentence. You have double jeopardy issues. You know, the sentence is over. You know, there's really nothing you can do to open it. And oh, by the way, the sentence probably was not illegal in the sense that they gave him too much fine or too little fine or something of that nature. So there's really not a whole lot you can do to kind of go back and correct the error. You know what I'm saying?
And it's more perverse than that, because the original charge normally is possession of cocaine or heroin. It will be downgraded by the county because of the proof problem or because of the amount of contraband to a 3510C, failure to make lawful disposition. The Supreme Court guidelines for plea agreements do not bar the 10C from being plea bargained, so that on the criminal history comes down to an ordinance with a disposition there. So the person who possessed heroin initially benefits from that process of permitted plea dispositions, whereas the person who possessed a very small amount of marijuana, because of the restriction against plea bargaining by the Supreme Court, does not have the benefit or opportunity to have that reduced to an ordinance, which you say is wrong under any circumstance. But the plea agreement prohibition just chops that process down entirely so that they don't have that benefit for what some would classify, I think most of us, a soft drug versus a hard drug.
You know, you've opened up like 15,000 cans of worms here with that comment. So
I'm sorry, but
no, I got to get into it.
But if you're the early bird, you're a happy man.
No, I have to get into this now. All right. Use the word perversion. All right, or perverse. And normally when you use a word like that, you stare at me, but that's beside the point.
For different reasons.
Well, you know, I used to engage in this activity, which there's no doubt about it, is perverse. I did it. I'm not proud of it, but I did it anyway.
Well, let's get this on
We're going to
camera.
get this on tape now because the statute of limitations has run out. I used to do what is referred to as a DILAG application. All right, this comes from a law division case called State versus DILAG. Here's how DILAG works. I'll just tell you a story. All right, it's a true story. You know, my law firm, my partner and I don't speak to each other. We haven't spoken in decades. So our secretary kind of runs back and forth between us. She came to me one day and she puts this leaking bag on my desk. She said 4 o'clock in the afternoon. She said, "You got to go to court tonight." Why? Well, your partner's got this case at the prosecutor's office and everybody wants to get the PTI, but he can't get PTI because he had a conditional discharge. I said, "Oh, when did he have it?" 9 years ago. "Oh, okay. Go to court, get it undone so we can get into PTI." So I'm figuring, well, you know, I'll go to Hamilton, I'll see all my buddies, you know, in local municipal court, I'll go to Trenton or wherever I'm going to be. And I look at the paperwork, it's in Passaic County. I mean, not even a regular Passaic County. I'm talking about Passaic County up in the Rocky Mountains, all right? A million miles away. And I'm riding up there thinking, I'm going to this place, nobody knows me, they're going to hate me. How am I going to justify this? So I drove all the way up into the mountains, Passaic County, and by some unbelievable miracle, the judge knew me, okay? So he invited me and the prosecutor to come into chambers, and we kibitzed a little bit, and then I told him what I wanted to do, which was vacate the conditional discharge. My guy will immediately plead guilty to possession of drugs or whatever it is, the drug offense, didn't matter. Possession of marijuana. They'll credit him for the deed or penalties he's already paid. He'll pay whatever additional fine you want, and everybody goes home, okay? The judge was a little hesitant at first. I had to work on him a little while to persuade him that it wasn't against the law, which it wasn't at that point. And he grants the application, okay? So now my guy, the conditional discharge is vacated. This is 9 years after the fact.
And the 5-year rule doesn't apply?
What 5-year rule?
Never mind.
We didn't have the 5-day rule then. But he vacates it. The guy immediately pleads guilty. The judge didn't even fine him anything. Credited him for the deed or penalties he paid before, so he didn't have anything new to pay. The judge should have suspended his license, but didn't. We go to the violations window, get a disposition letter. I bring it back. The next day, it goes into Superior Court and gets PTI. Okay? A year later, same thing. Debbie comes in, 4 o'clock in the afternoon, hands this leaking bag on my desk. You got to go to court tonight. Same thing. Different guy. Same thing. I look. Don't you know it's exactly the same court in the middle of nowhere in Passaic County? I got to go. I keep thinking to myself, this must be some big drug supermarket they have there for everybody in Trenton going to Passaic County to buy drugs.
Or the other side of one of the bridges coming through.
But, I'm going up there and I'm driving myself. I said, oh, I hope the judge doesn't remember I was here last year with the same nonsense. Oh, no, I hope he doesn't remember. He didn't remember, and this time it went through much more easily, okay? But same thing. The next day, the guy took the disposition letter to Superior Court. Bingo, bango, he goes right into PTI. Because we had removed the statutory disqualification. DILAG discusses that procedure. And I think in DILAG it had been like 16 years before they granted the conditional discharge and the attorney went back to open it up. You're in trouble when the case begins by saying that only 2 people can take something black and make it white, a lawyer and a painter, okay? But in any event, the law division judge was just not happy at all with the ability, this lawyer's going through this, getting conditional discharges vacated because it's inconvenient. It's like an inconvenient truth. It's inconvenient now because it's preventing the guy from getting into PTI.
And many times, that period of time, 16 years, is somewhat long for an individual who's indulging in drug usage. Many times, much prior to that, they're either in jail or very ill or dead, or they've changed their behavior modification and they're healthier, non-drug users.
Well, they get in all kinds of trouble. The cops find a pistol on them or something like that. They're a little bit more mature. They're creating adult crimes now, not children crimes. But all this has now come to an end as a result of a very unhappy case in the appellate division called State versus O'Brien. And O'Brien really just put an end to these dialogue applications by saying that the minute you make an application for diversion, in other words, you make your PTI application, that's it. It's the actually making the application which disqualifies you.
So no looking back from there.
Don't look back at all. If you apply
even if you're rejected in that process?
Doesn't matter. You made the application, you're out. Okay, that is the diversion, your ability to make the application. So if you make an application for conditional discharge, just the mere fact you made the application disqualifies you from PTI and from the municipal court, the conditional dismissal program. So it cuts off your diversions out of the criminal justice system at a very, very early stage in the proceeding, so to speak.
You may be singularly responsible for that particular decision.
I know, I'm so ashamed. But you can't do that kind of stuff anymore. So you got to explain to your clients, you know, you're going to go through conditional discharge. The minute we make the application, technically, if you get arrested for murder tonight, you're not going to get PTI.
Hence the discussion that you spoke of at the beginning of our meeting here today. Do you make that decision even before seeking the conditional discharge, or do you anticipate that this individual, based upon their lifestyle and history and social circle, will need that bite of the apple further down the road?
Well, you know, I say that. Sometimes I get a sense of my clients are cop magnets, and I say to them, you know, I'll tell you exactly what I say. I said, look, the cops aren't all that bright, but you make it easy for them, okay? Falling asleep in the middle of an intersection at 2 o'clock in the morning doesn't make it all that hard for the cops to figure out that you're drunk.
You say cops aren't all that bright, knowing that I was a police officer for 7 years.
I had forgotten.
I take that as a personal affront, but the truth hurts.
I had forgotten about your background. Now, let's talk about these guidelines a little bit, okay? They came out, I think, in 1989. And the Comprehensive Drug Reform Act was a lot simpler in those days, okay? And the guidelines generally prohibit plea bargaining in certain types of cases. They actually mention 3 specific drug offenses: being under the influence of drugs, possession of marijuana under 50 grams, and possession of drug paraphernalia. So far, so good?
35, 10A4, 35, 10B, 36, 2.
You can't plea bargain those cases.
So the Supreme Court guidelines prohibit.
Since 1989.
I'm not sure when. I have it here, but I'll accept that as it's been a very long time.
It's easy to remember. It was the same year you were born. In any event, the Comprehensive Drug Reform Act was amended maybe about a year into its existence to add in 2C3510C, which the failure to make a lawful disposition of a controlled dangerous substance. Now, you were right in the middle of this cocaine epidemic, and I know you remember arraigning hundreds, if not thousands, but certainly hundreds of defendants when you were municipal court judge for cocaine possession charges in Trent Municipal Court. Small amounts, though. I mean,
yeah, and crack cocaine is not what it used to be, but you still see it on occasion, but it is not like it used to be.
So my sense is that the legislature's answer, the reason they promulgated 2C3510C was in direct response to these small amounts of crack cocaine, which really have zero jury appeal. And by the way, I think there was an understanding that the people who got arrested for these things would get a lot more punishment and speedy justice in municipal court than they ever would in superior court. So 2C3510C was created to handle those types of offenses, and the Supreme Court never picked up on that and never added it into as a prohibition in the guidelines. Nor did they, and this was just an oversight by the Supreme Court, include initially 2C36.6 as possession of a set of works. So the 5 principal DPs that you have in the Comprehensive Drug Reform Act, only 3 of them are mentioned. 2 of them, just one by oversight and the other one by neglect, had never been included. We are probably up to around a dozen offenses that are defined now in the Chapter 35 and Chapter 36. Again, they've never updated the guidelines, so they were still dealing with the original 3 from 1989 that are prohibited. I guess theoretically everything else is in play, right?
It would seem so, but the social policy or progression leaves New Jersey behind the curve in the recent events in Colorado, for instance, and also Washington State and Washington, D.C. and...
In other words, the decriminalizing, so to speak, of certain types of drug use.
Of marijuana. And that, I read an article in today's local paper where the author, I think it was a professor at one of the local colleges in Texas, talked about a student who was using hash oil to make brownies, and because under Texas statute, the total weight of the brownies, as opposed to just the total weight of the hash oil, was what was calculated for purposes of the prosecution. This college student could face life in prison, whereas 90 miles north of where this event happened, he could buy this type of brownie even better and more flavors over the counter and have it be a perfectly lawful event. So the professor said something's wrong with this picture. He's not sure what the solution should be, but here's an example of how wrong various laws can be in treating the same conduct.
Well, we have kind of a similar situation when it comes to conditional discharges, and I want to talk about it a little bit because right off the bat, look, you can't plea bargain a drug case, at least with respect to ones that involve allegations of possession of marijuana, possession of drug paraphernalia, and
Use or under the influence.
being under the influence, okay, 2C3510B. However, there's exceptions. One of the exceptions is if you have multiple drug offenses arising out of one incident, and there's going to be a plea on one, the others can be dismissed as part of the comprehensive plea agreement, okay? Now, here's where the problems come in. You can also do something similar with respect to conditional discharges. If your client has a number of drug offenses coming out of one incident, possession of paraphernalia and possession of marijuana, for example, okay? You can select one charge to get the conditional discharge. The other one can be dismissed as part of your plea agreement, and everybody goes home happy. The problem that you run into is what do you do in those circumstances, because the court rules don't address this really, it's just kind of hanging out there like a chad. What do you do in those circumstances where the defendant gets kicked out of the conditional discharge program 6 months down the line? Does that revivify the dismissed charge, or does the dismissed charge stay dismissed?
It's my understanding that the dismissed charge or charges stay dismissed, but the preferred technique, and it's not often used, is as in DWI cases when there is a plea, which is many times conditional and later appealed and reversed or modified and the matter remanded. I believe there is a case that identifies that anything dismissed prior to that conditional plea remains dismissed, so the proper technique is a conditional dismissal based upon successful PTI completion. Mm-hmm. And that's particularly true of the motor vehicle companion to
the 449.1?
449.1, because that's a mandatory 2-year loss of license, and many times that goes as part of a conditional discharge process. The fine's minimal, but the 2-year loss of license is mandatory. So the technique, the proper technique, is to have that conditionally dismissed based upon the successful completion of the conditional discharge program. But in the scheme of things and the speed at which many of these cases is handled in municipal court, many times that dismissal is just blanket. And should the conditional discharge fail, the only prosecution is on the count for which the conditional discharge had been entertained. Yeah,
so I've seen some courts write down such things as like can dismiss without prejudice, but we don't have any. That's not recognized in the New Jersey rules. So I think conditional dismissal is probably better.
That's what's used in the DWI cases when it's done very thoroughly and carefully, and it's just very good form. Okay,
but I want everybody who's watching this to understand that you have this as an option, that if you have multiple offenses, you don't have to get conditional discharges on all of them, because then you have problems related to, well, the multiple license suspension part of it is not an issue, because Supreme Court's already described that you only get one license suspension, but you might have multiple drug enforcement penalties and things like that. You don't have to reach any of those issues. You just select whichever one you want to get the conditional discharge on, and the rest of it just gets dismissed.
If the court allows you to do that. Some courts will want conditional discharge on 2 counts, marijuana and paraphernalia, or 3, all 3, if it's used under the influence, and then merge 2 into 1, which is almost the same result. But that leaves everything open in the event the conditional discharge fails and it returns.
Got it. Now, there's a couple of additional things that I want to bring up. Again, sometimes these procedures get a little bit complicated, but let's just kind of go through it. First of all, the vast majority of conditional discharges that are granted on a pretrial basis. People come in and just they get their conditional discharge and that's it. But that's not necessarily the way it has to be done. There's really 3 options that you have available to you. Number one, you can do it with a plea of not guilty or no plea at all. Number two, you can plead guilty and get a conditional discharge, and sometimes prosecutors will insist upon that. That way you don't have to, there's nothing to try. If the guy gets thrown out of the program, you just come back and, sentence him.
But there is a license loss attendant with the guilty.
Well, I was going to get to that. And then the third way of doing it is to try the case. And if you try the case and get found guilty after trial, you can still get a conditional discharge, right?
It's permitted, yes.
Now, there are a couple things in play here that I want everybody to be aware of. The first is that if you request a conditional discharge, I'm going to start with the proposition that there's a license suspension associated every time there's a conditional discharge, regardless of whether it's with a plea or without a plea. The problem that you run into is that if you ask for a conditional discharge without a plea or with a plea of not guilty, the judge is then vested with the authority to decide whether or not to suspend the driving privileges.
But there's no mandate.
It's not mandatory, it's the judge's call. So the minimum suspension is 180 days and maximum is 2 years. And I guess judges would reserve this for cases where there's something egregious going on, where the drugs were possessed in a car or something of that nature. My experience has been, though, that judges are extremely reluctant to suspend driver's licenses on conditional discharges where there's no plea, because it would be a disincentive, first of all, for people to come forward and take advantage of the program.
And it would not tend to move cases. And one of the goals is to advance the docket, put this case as resolved, as opposed to push it further down the line. And
another issue, too, Bob, is that the guy's working, and we want to keep him working so he can pay these drug penalties. He's going to have $833 of drug penalties to pay. You certainly don't want him losing his job or being unemployable because he doesn't have a driver's license. It's really kind of counterproductive. You're setting the person up to fail, basically.
Which you don't want to do, but the system many times does that unintentionally.
Now, for the other two situations, if you plead guilty or if you go to trial and you're found guilty after a trial, that's perfectly fine. But under those circumstances, there's a mandatory suspension of driving privileges. And again, the judge has no discretion. It goes from 6 months to 2 years on either of those two situations. Obviously, if you try the case and you're acquitted, then there's no issue here. So this is the second and third ways of getting the conditional discharge: a straight plea or a finding of guilt after trial. But again, with the conviction comes the requirement of the mandatory license suspension. Now, having said that, and you alluded to this before, this actually came about as a result of some congressional action, and then the legislature kind of jumped onto it after the fact, of creating an exception for license losses, not only for drug convictions, but also for conditional discharges, in those instances where the defendant can demonstrate hardship. Okay? So a judge who is persuaded that it would constitute a hardship for the defendant to suffer a license loss, and since we're just talking about conditional discharges, let's stay within that realm, following either a not guilty plea or a plea of guilty or finding of guilty after a trial, notwithstanding what the statute says, the judge can still forego the license suspension in the event that there is a demonstrable hardship. Right?
Yeah, and I've seen that standard decline from the initial statutory enactment till today. It used to be, perhaps I need my license to get back and forth to work. Then I need my license to transport.
Or drugs.
No, not drugs, but individuals from my family back and forth to the doctor, to take my children to school, to get groceries for my family. And now I need my license to go look for a job. And the standards seem to be at this point, if you can say you need your license and it's somewhat reasonable, okay, we won't take it.
The seminal case on this is State versus Bendix, and Bendix has a really kind of an interesting story behind it. Bendix was initially, the appellate division decision, not approved for publication. And I sometimes think that the judges in the appellate division don't understand the impact of their own decisions because they're not involved in the trenches, so to speak. But there were enough municipal court judges, especially municipal court judges who are like the presiding judges, who recognized the importance of the decision. They actually wrote to the appellate division and importuned that panel of the appellate division to approve the case for publication because it was so critically important. So late after the fact, I'm talking literally months after the case was authored, finally was retroactively approved for publication. And Bendix is the case that actually sets forth the criteria that judges are to utilize in determining hardship. the most important one is exactly what you said, employment. Does the guy have a job? How's he supposed to get to work? Is there public transportation that's readily available to him? And it really kind of created a very, I don't want to use the word lax standard, but certainly nothing that's overwhelmingly difficult. And I think I agree with you. I mean, my experience has been it's really not a particularly high hurdle anymore. I think part of that is the recognition of the tremendous toll that not having a driver's license takes on working people.
In New Jersey particularly, it's the kind of state where you need that to live. One thought about conditional discharge after a guilty finding at trial, the leverage that many times is used by the prosecutor or court policy is if you push the proofs and they're found against you, expect a loss of license, because that's part of the risk you take. If you want the benefit of the diversionary program and you're willing to acknowledge that perhaps you need help and need rehabilitation, going to trial and being found guilty is not the way to demonstrate that acknowledgement. Like the federal court system, if you plead guilty, you're given points for that, for acknowledging past wrongdoing. So it's appropriate perhaps in the state system, if you're found guilty after trial on conditional discharge, okay, we'll allow you into the program, but you're going to suffer a license loss because you put the state to its proofs and they passed the test, so you have to take some consequences with that.
But isn't that a trial tax, Bob, when you come right down to it?
It absolutely is a trial tax, but there are trial taxes all over the landscape.
So basically the way it would work in modern day practice is I'm offering you conditional discharge. You're certainly entitled to conditional discharge after you're convicted, but the judge is going to take your driver's license away, and if you try to ask for a hardship exemption, I'm going to oppose it.
Sure.
Right. That's really the...
Yeah, it's the same thing as a motion to suppress being a trial tax. Okay, I'm filing the motion to suppress. All right, if you win, good. There's no prosecution, but if you lose, it's going to be a more aggressive prosecution, and there'll be a loss of license, and other consequences will flow. That's a calculated risk you have to take. If you didn't have these more aggressive stances for different legal maneuverings, you would never be able to move the docket.
Let me talk about a different situation, Bob. It's really kind of along the same lines, but it's another loophole in the rules of procedure that we have to kind of be concerned about, and that deals with exactly what you said, motions to suppress evidence. I mean, you've really got to file a motion to suppress evidence in every case that has a Fourth Amendment issue in it, just because you have to.
Well, some defense lawyers file that as part of their notice of representation. And
it's really
it's pro forma.
It's pro forma, but at least you've preserved it. Now, you have a situation where there is a condition. You have a legitimate issue. You go forward, you brief it, you have a hearing. Witnesses testify. You make your argument. You might even submit a brief, and the motion to suppress is denied at the end of the day. The judge denies it. Okay. So where does that leave you as a municipal court defendant? You're really kind of right back where you were. The only thing you've lost now is the Fourth Amendment issue. You could still go forward and try the case, or you can ask for a conditional discharge at this point, okay?
Well, a conditional discharge, preserving the right to appeal the denial of the motion to suppress.
But I don't think you have a right to, this is the point I wanted to make with you. I don't think you have a right to appeal the motion to suppress. I don't think there's any right that you have to appeal the denial of the motion to suppress.
I think I'd respectfully disagree on that one, because there is
go
a
to the video
disposition, but no doubt you're going to identify a decision that tells me I'm
I want to look at the
wrong.
court rules, because I don't think you have a right to appeal. And I'll show you why.
A conditional plea, that would be in Rule 7, would it not?
But you're not pleading. You're getting a conditional discharge.
Well, it might be a conditional discharge with a plea, but conditional discharge I would construe as being akin to a plea.
No, I don't think you can do it. Okay, here we go. What do you have to do to get into court? All right, here's the court rule that I was referring to. It's 3:23-2. You ready? Now here, let's go back to the setup.
All right, well, let me just counter with 761C, conditional pleas.
Okay, but you wouldn't use a conditional plea. It's not necessary in a conditional discharge, because in a conditional discharge, it's already preserved. Okay?
So the Rule 7 governs municipal court, and that's the conditional plea, which is with the approval of the court. So you have to have the court's approval to do that. And the consent of the prosecuting attorney, a defendant may enter a conditional plea of guilty, reserving on the record the right to appeal from the adverse determination of any specified pretrial motion. So that would suggest conditional discharge included as well for the motion to suppress denial. A defendant who prevails on appeal shall be afforded the opportunity to withdraw the guilty plea. Nothing in this rule shall be construed as limiting the right to appeal provided by 752C2.
I disagree 5,000,000,000%, and I'll tell you why.
That.
Because that rule would not, that applies to all types of pretrial motions except motion to suppress. Motion to suppress has its own rule, which is in Rule 7:5-1C2. Order denying suppression. An order denying the suppression may be reviewed on appeal from an ensuing judgment of conviction, whether the judgment was entered on a guilty plea or on a finding of guilt following trial. So once you file a motion to suppress and you litigated it, it's preserved automatically, whether you plead guilty or whether you take the case to trial. You don't need to do a conditional plea when you've done a motion to suppress. Okay, it's automatically preserved.
I understand that, but I've seen the 762C used after motion to suppress.
Oh, I agree 100%. It's just wrong. It's not necessary.
So the story of my life.
Now, here's what the point I was trying to make before. The guy has walked into court, gotten a conditional, he's done his motion to suppress evidence, blasted away, you blasted back. The judge, of course, as they're supposed to, state never loses a motion to suppress, as you know.
I didn't know that. I've lost motion to suppress, so obviously I don't represent the state.
That was not in New Jersey. But anyway, the judge denies the motion to suppress evidence. Okay? So now the defendant says, I want a conditional discharge. Okay? Judge gives a conditional discharge. What I'm saying to you is he has no means of appealing the denial of the motion to suppress, and I'll tell you why. It has to do with the wording of Rule 3:23-2. Okay? Appeal, how taken.
Which is cited in 751C2, the order denying suppression, which you've just mentioned.
Well, actually, let's start off with 323-1, okay? Okay, except as provided. Review of a judgment of conviction in a criminal action or proceeding of a court of limited jurisdiction shall be by appeal provided by 323. Defendant or defendant's, this is 323-2, defendant or defendant's legal representative or other person aggrieved by judgment of conviction, or the defendant or the state if aggrieved by final post-judgment order entered by a court of limited jurisdiction shall appeal therefrom, etc. Okay? So there is no mechanism to get into municipal court because there has not been a conviction. In fact, there's no judgment of conviction if you plead, even if you plead guilty and get a conditional discharge. Well, so I don't know how you get your foot in the door following a motion to suppress evidence if you've got a conditional discharge.
Well, in interlocutory appeal between the motion denial and the actual conditional discharge granting, they're disfavored, but that mechanism might be available if, as part of the moving papers, there was an indication this may be resolved by conditional discharge, but there is a substantial legal and factual issue as to the motion to suppress that we would ask be reviewed before entering conditional discharge. And maybe you'd be successful there on interlocutory appeal, disfavored as that is.
Well, I don't think the rules of court will actually allow the defendant to get into superior court on an interlocutory basis on a municipal appeal. The state can get in, I think. The state has an appeal of right, actually, if they lose the motion to suppress. But I think this is a quirk in the rules that there's really no way of a defendant who loses a motion to suppress and then gets a diversion to have his motion to suppress denial reviewed. I just don't think there's any mechanism out there to do it.
Well, I mean, if we want to be creative, if I were the defendant and I were dissatisfied, I would go to another attorney and have that attorney file an appeal on two reasons. That is, the facts and circumstances and ruling of the lower court on the motion to suppress, and also ineffective assistance of counsel for reasons A, B, C, and D. And I think a superior court would be very agreeable in hearing such an appeal process. I think if you're creative enough, you get that review, and I don't think you have to be creative to get it. But I'm obviously very wrong from your reading of the
rules.
Well,
no, it's just. Listen, I'm not. Listen, where's the state appellate division on my head?
It says Supreme.
No, you shouldn't say any of that stuff. But listen, this is why they have chocolate and vanilla. You and I disagree on stuff all the time, but this is, look, reasonable people can disagree about things. And you and I are two unreasonable
I was
people.
going to say, don't go calling me reasonable.
Let me ask you this, though. Did you ever stop to think, this stuff is second nature to us because we do it every minute of the day and night, but there really is a lot involved in the whole process of the conditional discharge. Wouldn't you agree?
There is, and a lot is involved from the defendant's perspective because they don't know what's going on generally. They know what the court tells them, which is very abbreviated. Hopefully their lawyer has explained to them the process, and for some individuals, it's just hard to stay drug-free.
Bob, I just have to go back to where we began because I see attorneys coming in to court with very young clients and taking cases that, look, who's to say whether or not there was a palpable or arguable Fourth Amendment issue that should have been argued, or maybe the case should have been argued on the merits or some weakness in it. I mean, you really shouldn't come between an attorney and a client, but I really have to stop and think about when I see a lawyer going up with a very young client and asking for a conditional discharge. And I think to myself, what's going to happen 15 years from now when this client gets in trouble and the lawyer says, you ever had a conditional discharge? And they say, yeah, I was 18 years old and I had one. So what you did all those years ago on some stupid drug offense is going to come back to haunt you. You know what I'm saying? It bothers me.
It does, but life is that way. What you've done in your youth affects your adulthood, and decisions you've made in the past affect your present and affect your future. I mean, there's just no way else of living.
Well, for the attorneys who are watching this, I just want to kind of give everybody some alternatives to the conditional discharge because you can accomplish the same thing. Sometimes you can actually do better by pleading guilty. Like, let me give you an example. Let's say you have a client who's under the age of 22, all right, and he possesses marijuana, under 50 grams, all right? He's better off pleading guilty. From every conceivable standpoint, he's better off pleading guilty. Number one, the fines and everything should be pretty much the same, or maybe slightly more than he would have gotten for the conditional discharge.
Approximately $1,000.
Right.
In that range.
He doesn't necessarily have to lose his driver's license if he can make a palpable hardship argument. It's got the same effect as the conditional discharge. Okay. More importantly, though, he can get his expungement within 1 year. He's eligible for expungement, in the sense that since there's a special provision in the expungement statute for youthful drug offenders, people who are under the age of 22. From the day he finishes paying his fine or serving probation or whatever it is he's doing, 1 year later he can get an expungement. So I'm saying, he's going to make out, he'll get an expungement literally faster than somebody who got a conditional discharge. But the most important thing is he has not sacrificed his ability to get PTI in the future. He's not going to be able to get a conditional discharge. He's not going to be able to get a conditional dismissal, but he can get PTI.
Right, so that looking ahead to something more serious in that individual's future, you're absolutely correct. But in that plea, because it is a prior drug conviction, he will have disqualified himself from availability of conditional discharge lifelong.
Correct. Now, for somebody who's a little bit older, maybe 23, 24, I still think you're better off pleading guilty. Again, you don't necessarily have to lose your driver's license. The money is going to wind up being the same. And if you're concerned about expunging it, now you have to wait 5 years instead of 1 year. But the bottom line is you've still preserved your ability to get into pretrial intervention in the event you need it sometime down the line. I just think it's a bad deal for people who, you just get a feeling that these are people who are going to be back.
Well, unlike you, I'm unable to predict the future, so I take a totally contrary view, and I say if it's available, take advantage of it because that's the best treatment you're going to get from the system. So use your get-out-of-jail card when you're in jail because that's the time to use it, and in the future, be smart and or lucky enough to stay out of jail.
But I have to take issue with it, and you said the magic word, card. Okay, you are Mr. Card Player, all right? And when you're counting cards, not that you would ever do this, but if you were counting cards, are you making predictions about the future based on probabilities?
That's exactly what you're doing, and that's exactly what life is.
Correct. So I, as a lawyer, I'm looking at my guy, I'm trying to assess him. Who are his friends? What's his educational background? What does he do for a living? How seriously is he taking this whole thing? What has been his background up to this point? I mean, all these are going into the mix, and I'm seeing a very high number here which leads me to believe that there's not a lot of face cars left, you know?
Well, I have a similar conversation with individuals in municipal court on traffic offenses, and they wonder on a speeding ticket, should they knock it down to 2 points or pay the ticket at the window at whatever point level or go to unsafe driving, and they say, what is your advice? Or they ask what my advice is. And I say, depends on the next 3 years, whether you're going to have any points, at-fault accidents, lapse of license or insurance coverage, and a whole host of things, changing insurance companies. I can't tell you what 3 hours ahead in my life is going to be, let alone 3 years in yours. So it's a decision I'm in no position to make.
By the way, you agree with my assessment about playing blackjack, right?
In that,
For the card counting, and you're making predictions about the future?
you're playing the odds.
Same thing with poker, though, except that instead of counting cards, you're really looking for indiscernible human behavior, betting patterns, body language, things of that nature to make predictions. Would you agree with that?
In all of life, you're essentially depending upon luck.
Right. Well, so it's really not reading the future, but luck. Would you say that's what it is at the end?
Luck is the greatest factor overall. The idea is luck balances out in the long term, but the long term is well beyond lifetimes, and skill cannot help but tilt the odds in the skillful person's favor.
Well, I know one thing, they'll be collecting the drug enforcement and the demand reduction penalty long after we're gone.
Well, I'm tending to think the New Jersey drug law will change in the medium horizon, but who knows? I can't predict the future. But that seems to be the national and worldwide trend. Was it Paraguay or Uruguay that nationally they've decriminalized marijuana?
I didn't know that.
That just happened in the past month or so.
The one thing that, again, is shocking to me is that there's so much involved with conditional discharges, and you know, if you ever stopped, like you and I are doing now, going through this exercise, there's a whole lot going on there, which you and I just do second nature. But for somebody who's kind of new to the game, I'm hopeful that this was a little bit, you know, helpful in giving them some options for their clients.
It's a good tool. It's a very useful tool in the tool bag, and in appropriate circumstances, it saves the day, and it does tremendous damage control.
Bob Ustemski, Municipal Prosecutor, again, thank you so much.
My pleasure.